Hey everybody, welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel, and it's been a couple weeks, so I apologize for that. I've been out of town, had a lot of things going on, but we're into summer now, and back in the saddle here on the Consumer Warrior YouTube channel. Again, my name is John Skiba. I'm a bankruptcy attorney and a consumer defense attorney in the state of Arizona, and here I also founded the Consumer Warrior YouTube channel to really provide information to people who are struggling with various debt problems. They're not sure what to do, just really to get some basic understanding of what the different options are that are out there. Because I am a licensed attorney in the state of Arizona, that means I'm not licensed anywhere else, and I can't provide any legal advice. If you are not in the state of Arizona, I'd highly recommend you contact an attorney in your neck of the woods to be able to help answer questions and provide specific legal advice. This is just me talking on YouTube, so take that is for what it is worth. And so how we do this each week is if you have questions and you're on YouTube, go ahead and put them in the chat section, and I will put them up on the screen, and we will talk about them and kind of give you some tips and some strategies of what I have seen work on how to deal with serious debt problems, particularly as it relates to bankruptcy, those types of things, debt collection lawsuits, junk debt buyers, all of that. So if you have questions, go ahead and put them in there and we can start addressing those. One thing I do like to do is go in and check out all the comments that people leave to the videos that I've been posting. You may have noticed we've been posting a lot more frequently. I'm trying to put up at least 3 videos a week on various topics. And so if you do have questions and you can't make it to, if you're watching this after the fact, you're not watching it live, go ahead and put your comment in there, and I may put it up here on the screen and we can talk about it. So one that kind of caught my eye this week is this one. Excuse me. This person says, hello, would it be possible to pay off my car loan with a credit card and then file for bankruptcy? This is getting a little bit, we're trying to get a little bit sneaky here. I would not recommend you do this. One, it's considered fraud. It's fraudulent. If you're incurring a debt with the intention not to repay it, that can be considered fraud. And I can tell you, I've been doing this for almost 20 years. I've met with more than 10,000 families who are dealing with debt problems. I almost never see this issue come up where someone intentionally incurs a debt with the intention of filing for bankruptcy. I just don't see it happen that often. Most people, they enter into debts. Sure, are bad decisions made? Absolutely, bad decisions get made. But I don't see that happen too often. So in a situation like this, if you were to pay off your car loan with a credit card, and particularly then if you file bankruptcy within 90 days prior to you filing your bankruptcy, you did that within that 90-day window, the credit card company can actually come in and raise an objection to your specific debt from going away. And so, that specific charge. So it's not something that I would want to mess around with. You're going to end up causing some problems for yourself in the bankruptcy. It's best to talk to the bankruptcy attorney and put together a plan that'll actually be a good one. So, all right, Angie, thank you for tuning in. And Audrey's asking, where have I been? It's been 2 weeks. I try to do one vacation a year. And where we go, our family, we go to Lake Powell. If you're from Arizona and you have not been to Lake Powell yet, you're missing out. It's one of my favorite places on earth. We go up there for 1 week and try to escape everything for a while, and it was awesome. So it just happened that we were leaving on a Thursday, coming back on a Thursday, and it made it difficult to get in the to do the live stream. I thought about doing a live stream live from Lake Powell, but that wouldn't have been good. So, all right, let's see here. I had another question from the comments. This person said, I said, the only way to stop a garnishment on a default case is to declare bankruptcy, but I filed a form to reopen the case and now have another hearing to handle this matter. Is this normal? So if you get hit with a wage garnishment, it's often true that to stop it, a lot of people have to file for bankruptcy. That's kind of the tipping point for most people. if they file for bank, if they're dealing with a debt problem, if a garnishment hits, like in Arizona, they can take 25% of each paycheck. So it's a huge thing. I saw a statistic from Dave Ramsey once: 78% of American households live paycheck to paycheck. So if all of a sudden a full quarter of your check is gone, it makes it tough even just to pay very basics, particularly now where these prices are out of control. In a situation like that, that often pushes people into bankruptcy. But you can object to the garnishment. If you have a legal basis to object to the garnishment, you can go in and tell the court you don't think they have a valid judgment. Often it has to be followed with a motion to vacate the default judgment. And there's some procedural ways to get that done. So that's not the only way to get it done, but it is one way to get it done. So, all right, let's see here. Marcos had a question, said that he got a really good settlement offer from PRA, that's Portfolio Recovery Associates, but they want me to sign a mutual release. Is this advisable? So what this is once you negotiate a settlement, if you're talking with your creditors and you come up with a dollar amount that you're going to pay that you feel comfortable with, you can actually, you want something in writing. And usually that's in the form of a release. It'll say settlement agreement and release, or settlement agreement and mutual release. And what it is, this is important because before you pay them money, you want them to acknowledge what the settlement is, what you're going to pay, what they're going to do. They're going to dismiss the lawsuit. They're going to eliminate the debt. If they're going to update your credit report, whatever it is that they're going to do, you want them to be able to fill all of that out. The thing that gets a little bit tricky is the mutual release. So the mutual release is what they're saying is PRA is saying, hey, we are not going to hold you liable for this debt anymore. It's done. You don't owe us. You're going to pay this. It's done. They also want you to release any claims you may have against them. I can tell you in most situations, this isn't a big deal. Where it could become a big deal is if you believe that you have like a violation of the Fair Debt Collection Practices Act, the FDCPA. If you feel like they did something in violation of this FDCPA law and that you have a claim that you want to bring against them, that could cause an issue, because if you sign that, you're giving up all of those claims. Like I said, in most cases, it's not a big deal. But if you feel like you may have a claim against the debt buyer or the debt collector or whoever it is, you might want to talk to an attorney before you sign off on that mutual release. All right, let's see here. Sam says, I originally had a credit card with FIA, and FIA Card Services was bought and merged with Bank of America. Would you ask Bank of America to produce the bill of sale if Bank of America is suing you? So the one thing, this is a little bit different than junk debt buyers. So we deal with junk debt buyers quite a bit, where we have Synchrony Bank selling to Midland Credit Management, that kind of thing. When it comes to Bank of America, so FIA Card Services is actually kind of a subsidiary of Bank of America. It's kind of their credit card wing of things. So you have this Bank of America umbrella, and they have their checking and their investing and their retirement accounts and all that kind of stuff. And they also have their credit card division. That's what FIA Card Services is. And so you're not going to see a direct bill of sale, but if you were to ask what's the relationship between the parties, that is one where they're going to be able to provide documents. I think they're even available on I think it's on the SEC's website, or the Federal Trade Commission's website, the FTC's website, where you can actually see that. So that's something where it's a little bit different, and that's not going to give you a lot of bang for your buck. You may want to do something more like what Monica's talking about here. Monica says the Bank of America is suing for a credit card debt, but she can't find the arbitration agreement anywhere. Should I still try to compel arbitration? So, and as a background, all the regulars here know this approach, that if you get sued by a credit card company, one approach is you could say, we want to have it dealt with through private arbitration. Private arbitration is essentially where you're renting a judge to hear your case instead of going through the court process. Now, so you could enforce that, and you can force the case into private arbitration, which Bank of America and none of the credit card companies want to do. That's why they filed a lawsuit in the court system. But you have to find that clause. And some of the newer credit cards, I've had people point this out here on the channel, when they get the terms and conditions, for their credit card agreement, they're seeing that there's no arbitration clause in there. Now, you need to make sure you have the right terms and conditions for your specific credit card. The best place to do that is at the Consumer Financial Protection Bureau's website. I'm blanking on the website off the top of my head, but it's Consumer Financial Protection Bureau. Just Google that. They actually have a section there. This is a government website. So they have a section there where you can do a search for all the terms and conditions of your particular credit card, your year, all that. Go through and look. Usually the beginning of the arbitration clause is in all caps. And so if it's there, great. If it's not there, I wouldn't recommend filing a motion to compel private arbitration, because the only reason why this typically works as a strategy is because if their agreement has that arbitration clause in there, you're asking the court to enforce their own agreement. If it's not in there, it's likely the court's not going to force them to go to private arbitration unless there's something that you can actually point to. So, Alex, you made it. I hope you're doing okay in Yuma. Summertime, it's getting hot. We're getting crazy rain up here today, though, which is kind of weird. So thank you for that. Same, Monica, thank you for the super sticker there. And Marcos, thank you. Appreciate it. So, all right. So not seeing any other questions today. I hope some of that helps. I'll get back in, like I said, the regular thing, flow of things. If there are topics you want me to address in other videos, like I said, now that I'm committed to more of a 3 times a week releasing the videos plus the live stream, I always need help in deciding what type of topics people want to hear about. Put them in the comments here. Put them in the comments on the YouTube channel. I do take a look at those, and I'd be happy to help with them. All right, let's do one more. Eugene, you barely made it. All right. Eugene says, I have a 4-year-old credit card of $5,900. I was hospitalized for long term, and it was written off, but it kept hanging on my credit report. I had it removed, but it kept coming back on. What should I do? So this is a good question as far as what it means to have a written off. It actually reminds me of I was just watching on YouTube. I saw an old Seinfeld clip where Kramer was talking about, hey, they're just going to write this off. And Jerry's like, what does that even mean? And he's like, I don't know. And he says, well, you don't either. And he says, but you know who does? The banks, because they're writing it off. If a debt is written off, charged off is what you're going to see. Like on your credit report, you're going to see a CO if it's been charged off. The charge off is really just an internal tax classification or tax treatment of the bank. Essentially what they're saying is, hey, we've charged this off. We have deemed that this debt is no longer collectible. And when they report on their books, it's going to show up as bad debt, something that they're not going to show it as an asset of the company. And so when they charge it off, a charge off alone does not mean that it's going to fall off your credit report. And it also does not mean that they're not going to sue you. I've done a couple of videos on this. This is where I get the most haters online, is when I do videos that say that charged off debts, they can still sue on them. 100%, absolutely they can. I deal with it every day of my life. They can. But the charge off can stay on your credit report for up to 7 years, because it's a derogatory or a collection account on your credit report. It can stay on there for 7 years from the time that the account goes into a default or to collections. So unfortunately, Eugene, so what you're doing here is you're disputing it. And usually what happens is then the credit reporting agency like TransUnion, Equifax, Experian, they reach out to the creditor to get them to verify it. If they don't, they have to remove it, but then they can submit it again if it's something where it's a valid debt, and it can stand there for 7 years. So you're 4 years into it, probably 3 years, it'll be gone, if not sooner. So see what Greg has to say. Have you dealt with Snap-on Credit? Has it been charged off, do they usually sell the debt? I've dealt with Snap-on before. My dad and my brother are mechanics in Utah. They own a an auto repair business. So I know what Snap-on is intimately. And I know how big those bills can be. And I know how much those toolboxes cost that they sell, and they're out of control. But as far as whether I see them charge it off, I haven't dealt a ton with Snap-on, but they'll charge it off, but I don't usually see them sell their debt. What I have seen, at least and where I've dealt with them is in more of a bankruptcy context. They still Snap-on kept the debt and continues to try to collect on it. most companies that sell the debt, they're dealing with gigantic volume of consumer cases. We're talking millions of accounts that they can sell off, because usually it's not profitable just to sell something less than hundreds of thousands of accounts kind of thing. You do see it sometimes, but not a lot. So all right, all. Hey, thank you for all checking in today. Check in back next week, Thursday. I will be here. I promise I will be here, and appreciate all those who are contributing to the YouTube channel. I really appreciate it, and we'll take it from there. We'll see you next